Good morning. Today is January 15, 2026. It is approximately 9:30 a.m. This is the matter of a conditional use permit application Z0380-25. The applicant is Mike O'Malley of O'Malley Brothers Forest Products. My name is Carl Cox. I'm a private attorney appointed by Clackamas County as Land Use Hearings Officer with authority to conduct this hearing and make a determination in this matter. I'm going to make a statement for the record, and I have a couple of important things to state. I've not received any ex parte contact in this matter, meaning no one contacted me outside of these proceedings to try to persuade me concerning a fact or issue present in this matter. I've considered issues of bias and conflict of interest, and I've determined that I do not have any bias or conflict of interest in this matter. The county is making a record, recording this hearing, and that record is available through the county. Prior to the end or the close of the record, I'll make a statement about requests to keep the record open. We'll do that before closing this hearing. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues related to the proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once final, this decision may be appealed to the Oregon Land Use Board of Appeals. All right, at this time, I'm going to ask that the county provide an explanation concerning participation in this hearing via the Zoom platform. And also, Ms. Reinhardt, do we have public participants other than the panelists? Yes? Okay.
Today's hearing is being recorded as required by law. I am going to read more information about the Zoom meeting, but additional information will be in my PowerPoint presentation on slide 2. So if you have any questions, you will see this information again. The county will make every effort to post the recording of this hearing on the county website later today. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members' camera will not be turned on at any time. The audience members' microphones will be muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will use the raise hand button. For people who have called in by phone, you can press *9 to raise your hand. Staff will call upon you when it is time for you to provide testimony. You will unmute your microphone and then provide your name and mailing address when you begin. Once you have provided your testimony, you can lower your hand and your microphone will be muted again. If the record is left open at the end of this hearing and you wish to submit additional written testimony, you can email the written testimony to myself, Joy Fields. My email is jfields@clackamas.us, or you can mail it to Clackamas County Planning and Zoning, 150 Beaver Creek Road, Oregon City, Oregon, 97045. My email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who wish to testify and provide their mailing address will receive a written notice of the hearings officer's decision and a link to access the full written decision. If you do not wish to testify but would like to receive the decision, You must provide your email or standard mailing address by emailing me at jfields@clackamas.us.
Good. Okay.
Okay.
And the order of proceedings here, I'm going to ask the county to begin the hearing by providing a presentation concerning the county's staff report. That presentation will have Ms. Field's email address on it, I believe, so that will be available to anyone that has video capability here or following the hearing. As Ms. Field stated, when she uploads this to the county website, you can review that, and her information is posted in a couple of places there. That presentation, I understand that the applicant also has a presentation prepared in advance of this hearing, so that the applicant will have the same opportunity following Ms. Field's county presentation to provide that presentation. Then I'll make an opportunity available to members of the public who wish to provide comments or testimony or submit even a written statement for my consideration in making a decision in this matter. Are there any questions before we begin? Okay, and I will have some questions, so we'll deal with those as we move along. Ms. Fields, will you please begin?
I sure will. Are you all seeing the next slide?
I see a slide and I see the following. I see your Zoom meeting instructions as well.
I am going to try to um, get it so that that is not the case. So bear. Okay, thank you. As the hearings officer mentioned, we are here for file Z0380-25. And my email is on the slide before us, jfields@clackamas.us. I'm having technical difficulties.
Technical things require a little patience.
It would not let me progress to the next slide.
I'll share my own technical issue. I checked my the link to the exhibits, and it apparently hadn't refreshed, so I didn't see there were additional exhibits until shortly before this hearing. I skimmed them, but I will read them in detail. I promise.
Okay. As discussed, we are using the Zoom platform for today's public hearing. There is an opportunity for public testimony. The hearings officer will let you know when that is. When you are unmuted to provide testimony, you will use the raise hand button or press *9 to raise your hand if you're joining us by phone. At the beginning of your testimony, please state your name and your mailing address, and then lower your hand when you finished. If the record is left open to provide additional written testimony and you would like to provide additional testimony, please email it to myself at jfields@clackamas.us or mail it to our office. We are here today because there is a property on Highway 212 that is approximately 9.78 acres. It is zoned RRFF5, and they are requesting approval from the county for a conditional use to allow the commercial and processing activities in conjunction with forest use. The proposal specifically includes the commercial and processing activities that include storing logs, sorting logs, and air drying logs that have been removed from other properties and brought to the site. In addition to the logs, the applicant is requesting to store logging equipment and logging trucks on the site. Prior to today's hearing, comments were received from ODOT, the Transportation and Engineering Division, and a member of the public. The transportation agencies discussed traffic impact. In addition, the Transportation and Engineering Department is also the Surface Water Management Authority for this, or Surface Water Management Agency for this site, and provided surface water findings and conditions of approval. A member of the public did provide input into this and had concern about surface water management on the site. They also indicated that they wanted a zone change for this whole area. Today's application is not a zone change application. It is a conditional use application. Looking at the criteria that the application is subject to and the materials provided by the applicant, the staff report found that the criteria could be met with conditions. And so staff recommended approval with conditions. The site includes several aspects. As I discussed, they're wanting log storage. And so there are areas of log storage included in the site plan. They're also wanting to have logging equipment here. And so there's several areas on the site where they are proposing equipment storage. And then they're also proposing covered wood storage area in the central eastern portion of the site. They identify the parking area on the site plan, but do not specify exactly where that parking is located or how many parking sites there are. I apologize. This is no, I guess it is relevant to this application because the applicant is proposing commercial and processing activities in conjunction with forest use. We look at the definition of commercial use in section 202, and it is a professional service that the applicant is proposing, and looking at that guides our understanding of what sections of the development standards are applicable to the proposed use, because commercial uses are applicable to several sections of the 1000s for development. As noted in the staff report, the property is zoned rural residential farm and forest, and the proposed use is identified as a conditional use in that zone. Therefore, looking at the conditional use criteria in section 1203 of our zoning code, we found that we could process this application for a conditional use. 1203 also requires that the characteristics of the subject property are suitable for the proposed use and guides us to consider the size, shape, location, topography, existence of improvements, and natural features in making our determination. The site has direct access onto Highway 212 and is in close proximity to Highway 26. In the background of the proposal, the applicant identified that as a key piece for why this site is suitable for the proposed use, because it allows quick access to move these forestry related um, and commercial equipment to sites other than the proposed location. Staff find that the size is sufficient to meet the proposal based on the site plan. The shape of the property is rectangular, except for a small bit that has been used for right-of-way for the state highway. The topography is relatively flat. There are no steep slopes known on the property. There's no permitted structures on the site. And at the lower portion of the property, there is habitat conservation area as well as a water quality resource area identified on the site. The conditional use criteria requires that the transportation system be adequate to serve the proposed use. ODOT reviewed the application, and the applicant provided a traffic impact analysis for the proposed use. And ODOT found no concerns about the traffic impact analysis. That found that because most of the trips were outside of the high traffic times, the transportation system was adequate for the proposed use. And there's limited number of trips proposed from the proposed use. Therefore, staff found that the requirement for transportation system concurrency was met. Another criteria that was considered was that the proposed use cannot alter the character of surrounding properties in a way that substantially limits, impairs, or precludes the use of the surrounding properties for the primary uses allowed in that zoning district. And the proposed use, with proper buffering and storage, will not substantially impair or preclude surrounding properties from conducting their primary uses. Staff considered noise, traffic. Lighting was not identified on the site plan or provided in sufficient detail to know exactly where the lighting was. And so as conditioned, the ways to make it not impair or substantially preclude the use of surrounding properties is met with a design review condition of approval. The proposed use is consistent with the applicable goals and policies of the comprehensive plan. The applicant found that the forest goals were primarily what they addressed as being applicable for this use, and found that using this site that is zoned rural residential as a site for storing logs and storing the equipment that will be then used off-site was a way to protect the forest lands in the county from being developed by other uses and protect forest lands by supporting the timbering of those lands. Staff found that that was a reasonable argument and found that the proposed use is consistent with the applicable goals and policies of the comprehensive plan. The rural residential zone is identified in Chapter 4 of the comp plan with goals for rural residential, and this application, considering the use and ways to mitigate any impact of the use, make sure that this application is also consistent with the rural residential goals and policies. The approval criteria for conditional uses make sure that the overlay zones, any special use requirements for the proposed use, and the development standards are considered and met. The overlay zones for the subject property include the habitat conservation area and the water quality resource area. Those sections are in the 700s and are addressed in the staff report. Um, in the landscaping plan provided by the applicant, equipment was shown to be located inside the habitat conservation area, and equipment is prohibited from being within the habitat conservation area unless there is a habitat conservation area development permit. In addition, when there is development, which in the design review world, development includes site development, such as clearing and grading property. A construction management plan is required in the habitat conservation area. The habitat conservation area also has a definition of development that includes vegetation removal and grading. And so when there is habitat conservation area on the property prior to grading or site development or the removal of vegetation, we need a permit for a construction management plan. That is usually reviewed by staff during a building permit process, but if there's no building permit required for this use, then it could be reviewed prior to initiation of the proposed use. And I found that there was a typo in the staff report where prior to was missed in the condition of approval. So I
What
did
page
want
is
to
that,
highlight.
if you don't mind me saying, asking?
Do what?
Never mind. I'm understood.
Yes. The water quality resource area is not identified in the metro maps that identify water quality resource areas, but it is identified in the statewide wetland inventory at that southern area of the property. Um, in the water quality resource area, they identify that the text of the zoning code um, can determine whether a water quality resource area is present. And using studies that are from experts that inform the statewide wetland inventory, staff found that there was a water quality resource area on the property. And so that overlay zone applies. And thus there is a condition of approval related to that. The applicant did review the conditions of approval and requested modification of that condition of approval. Um, from the materials that I have in front of me, those amended conditions of approval seem suitable. However, I have not seen the wetland delineation that DEQ required for their case file, and so I don't know if that is anything different than what the applicant provided for this application.
Let's take just a moment. Ms. Kellington, Ms. Hudipole, is there still an outstanding issue with that proposed condition of approval as rewritten?
Uh, I'll let Kelly talk about the specifics of the condition of approval, but to answer the question, DEQ is not requiring a wetland delineation. The area in Bo Ellis's letter, who is the attorney dealing with the DEQ matter, he wrote a letter for the record that was submitted yesterday. He explains that in some detail. What DEQ is requiring is that, decades ago, there was a historic watercourse ditch of some sort that went from east to west across the subject property. Somebody put fill into it years ago, and DEQ says that the applicant here did it. The applicant says they did not. There's definitely evidence of old fill, and the DEQ and the applicant are sort of putting away the disagreement and are dealing with the restoration of that historic conveyance, not as a wetland, but as a way that would convey water per its historic methodology, I guess, system from the impoundment on the property to the east, cross the subject property either via ditch or undergrounded to the property to the west. So there is no DEQ wetland delineation requirement. There is a wetland that shows up on the subject property to the south that is within the habitat conservation area that if it exists, it shows up as being pretty much coterminous with the area of the intermittent stream. And what we suggested was a condition of approval that required that we delineate that wetland that shows up if it exists, that shows up on the state wetland inventory that Joy was talking about in the south of the property so that we knew exactly where it was so that if it is not coterminous with the HCA, which we are staying out of, we don't have anything in there right now, that we would be able to delineate where it is, know where it is, and certainly stay away from it, as well as the required vegetated corridor from it.
Okay. I don't, when I look at the proposed conditions of approval, I don't find anything inconsistent with what you just stated. It just states but it does state a habitat conservation area development permit will be needed.
So I think on that the HCA permit will not be needed. There was a disconnect and we're responsible for it and apologize for it. The application papers and the site plan clearly show that the all of the equipment and you know activities on the subject property are outside of the HCA and then submitted a landscape plan from an older aerial that showed some equipment in the HCA. But since that old aerial took place, as is described in the declaration of Evan Brueggemann in the record as well as it's in the application materials, there is no equipment, there is no disturbance within the HCA. And so our understanding is that having clarified that information based on sworn testimony and images, that we would not require an HCA permit. My understanding is you only require that if you are disturbing land within the HCA, and that is not proposed, and we're willing to accept a condition of approval that we not do that in the future either.
Okay. And so you're asking me to modify the proposed condition of approval 9, habitat conservation area development. Let's move on and get back to this because I'd like Ms. Fields to have an opportunity to finish. And Ms. Fields, what do you have a statement about this controversy over condition of approval 9? We can wordsmith this to state, refer back to the state agency that if they require it, you do it.
So, two different things. The water habitat conservation area prohibits equipment from being stored in the habitat conservation area.
Right.
And unless there is a development permit. And the reason for that is the development permit allows for mitigation. So any removal of vegetation to store that equipment in the HCA would be mitigated with additional plantings elsewhere on the site or to as a buffer for the HCA so that it's not impacted. I don't have a concern if you modify the condition of approval to ensure that future development and equipment remains outside of the habitat conservation area and no vegetation removal is conducted inside that area.
Okay.
I would say that the construction management plan is a is still probably needed to ensure that as they are meeting the requirements from transportation and engineering, there's no impact to the habitat conservation area.
Do you agree, Ms. Kellington? Construction management plan to keep the equipment and development away from the designated.
I don't think that that's problematic. Thank you.
Yeah, thank you. Okay. Please proceed, Ms. Fields, and thank you for pausing a moment.
Of course. Um, that was the primary location that I was going to address those overlay zones. So I am glad that you paused us there to talk about it. The other modifications to the conditions of approval that the applicant requested are addressed down below relating to the 1000s. When I refer to the 1000s, I'm referring to the development standards in section 1000 of our zoning development ordinance. And those also have to be met by conditional uses. Staff found as conditioned they could be met. One of the ways that it was conditioned was through a design review. And I want to highlight the purpose of section 1005. I am only highlighting the lower portion that is applicable outside of the urban growth boundary and outside of urban areas. But 1005 is intended to reduce impacts of development on natural features and vegetation, to utilize opportunities from the site's configuration or natural features, to encourage green building technologies, to design sites so that dark skies are maintained, thus the outdoor lighting requirements. And there's a condition of approval in the staff report for a lighting plan. And to accommodate the needs of the users to be located in the development. So the staff coming to the site and parking and going to the equipment storage areas. That is the intent of 1005. And then within 1005, there's specific design standards that are intended to support the intent of the section. And they include clustering buildings, orienting buildings so that it gets south facing for solar access. It also includes a continuous interconnected on-site walkway system. And I highlight that because the site plan provided by the applicant did not identify a walkway system or how the staff that come to the site move about the site. I also want to highlight that staff looked at this as though Connex storage devices are structures based on a previous hearings officer decision. And a structure is defined as anything constructed or erected which requires location on the ground or attached to something having a location on the ground.
Right.
And then a building is any structure used for sheltering any use. And so, therefore, staff considered the Connex storage structures that you see here in the aerial image as structures. And then, because they were intended to shelter equipment, they are then buildings. And so my staff report is from that perspective. In the application materials, the applicant did not request a modification to the building design requirements of 1005. And so staff was unable to find that the Connex storage structures met the building design requirements, and weren't able to find that they are suitable for the use, because no modification was requested for the roof design or for the other requirements in the building design section. Therefore, they were included as conditions of approval to be evaluated further through design review. The applicant requested in their modified conditions of approval that the buildings be removed from future design review. That is one reason I am bringing it up here now.
Okay.
The landscaping requirements found in 1009 are one of the ways that conditional uses are often separated from and buffered and screened from adjacent properties. Because the applicant didn't identify the number of parking spaces, the surface parking and loading requirement for landscaping was met as conditioned. However, if there's less than 15 parking spaces, then that section becomes not applicable. Erosion control and mitigation, it has to meet the requirements of the Transportation and Engineering Program since they are the surface water management agency for this site, and they have requirements that were included as an exhibit and also as recommended conditions of approval. The maintenance of the landscaping was met as conditioned because staff were unsure of whether additional landscaping would be needed. I am highlighting this because the applicant requested that landscaping be removed from the design review aspect of this application, or the design review condition of approval for this application. Staff have no problem with that as long as there's less than 15 parking spaces and there is a condition of approval that the evergreen trees planted along the eastern property for screening and buffering are replaced as needed to replace trees lost to disease and death.
I saw that.
Additionally,
Just a second. Is the requirement fewer than 15 or 15 or fewer? Less than 15. So 14 or less.
Yeah, the landscaping requirements for parking areas is for parking areas that have 15 parking spaces.
Okay, so 14 or less is exempt. Thanks.
Can I ask a question of Joy? Is that inappropriate?
Yeah, we're here.
Yeah. So, Joy, does that include parking the log trucks, the tractors, or is this just the, 6 employees who come in, pick up a truck and leave?
We use the standard for all development. And usually when we look at surface parking and loading landscaping requirements, it's around a parking lot. And so I think that the logging equipment would be outside of this because it's not in a parking lot. If you look at 10903, it's about swales between parking lots. It's about buffering adjacent properties from the parking lot. It's that type of requirement, and it's making sure that there is separation so that the parking lot doesn't drive into the landscaping. So I don't believe that the logging equipment storage areas would be subject to this.
Right. That's what I would think too. Thank you very much. Sorry.
It seems to me that this isn't an issue because if it's 14 or fewer parking spaces, you're going to identify them on your site plan, where they're going to be and how they're and if you have to have a walkway from the parking area to the storage area, let's call it storage of logging equipment, storage of related vehicles, but those are stored commercial equipment versus parked vehicles. Okay, I think I fairly framed that. All right, Ms. Fields, thank you for the explanation. I thought that was very clear.
One of the pieces that would be lost if you accept the condition of approval as proposed by the applicant for the design review condition of approval was 1021, the solid waste and recyclable material collection. There are requirements in 1021 to make sure that the access location of the pads and enclosure meets both what the franchise hauler needs as well as is safe and is safe. I'll leave it at that. So that there's nothing dripping, so that it doesn't create a hazard from vectors such as rats or whatnot. And so if you accept the modification to the design review condition of approval that the applicant proposed, I would request that you add 1021 to that to make sure that the solid waste and recyclable material collection meets the requirements of the ZDO.
Okay, thank you. That doesn't seem very controversial. I'm a little concerned about the design review. I want to talk to you about that a little more, Ms. Skellington and Ms. Hudable, but either way, I don't see an issue that a condition of approval that the receptacle that you have to have for garbage pickup, I think you use a dumpster on site, has to meet the ZDO requirements seems like a non-issue to me.
It is a non-issue. I mean, this site generates almost no trash, no recyclables. I mean, it just doesn't. So yeah, this isn't a problem. It's just an oversight on our part. No worries.
Ms. Fields, thank you again.
So I've highlighted the majority of the sections that were found to require conditions of approval to be met. The other sections of our zoning code were found to be met or not applicable with this project. And that concludes my presentation.
Thank you. I'd like to give the applicant same opportunity. I understand you have a presentation and I have some questions there as well.
Thank you. Hello.
Probably just need to use that. That's the microphone.
Kelly, you're muted. Kelly, you're muted.
Perhaps you have more than one line open at the same time.
I'm not the bad guy because I'm in Pendleton.
Is there
Apologies,
somebody
everyone.
in
We
the
had
same room as
Very
Kelly with?
extreme reverberation over here. I don't know if you all had that as well. I'm Kelly Hudipole on behalf of applicant with Kellington Law Group. Applicant does have two panelists here. Wendy Kellington has already spoken, also an attorney with Kellington Law. We do have a presentation. Thank you very much. I'd like to thank the hearings officer for his time today, Ms. Renhard for setting this up and her time as well. And I'd especially like to thank Joy Fields for taking the time to so thoroughly review the application materials and to speak with us to answer some questions that we had after the staff report was released. We really do appreciate that. We do have a presentation today. I'm going to go ahead and share my screen.
And you'll submit this as an exhibit also in Ms. Fields as well. Thank you.
All right, is everyone able to see that?
Yes.
This is the presentation for the O'Malley Brothers property, which is on Highway 212, just east of the Highway 212 and 26 intersection in Boring, Oregon. The property is just under 10 acres. It is sloped or upgrade from the west, meaning it is higher than the elevation on it is higher than the property to its west. The historic drainage across the property has been identified by DEQ in connection with some review they are doing of the property, and they have identified a historic drainage course that they are requiring to be restored. The drainage amounts, as they historically have been under the state laws of Oregon, are being assessed by DEQ, and the owner and DEQ are currently working through exactly what that is going to look like on the ground. But DEQ has taken jurisdiction over the surface waters on the property and their resolution, and so that is not a matter that applicant understands is in the county's jurisdiction or a part of these proceedings. That is something that is being worked out with DEQ, will of course be reflected in the stormwater management plan, et cetera. There will be a 1200Z permit that will be issued. The property, this 10 acres, can be thought of as being in two parts. The southernmost part of the property is a habitat conservation area with an identified water resource running at the very southern edge of it. This is forested and vegetated area. North of that is what is a logging staging yard. Applicant runs a forestry operation. There's no dispute about the fact that what applicant does to earn revenue is a forestry operation. They go out into forest lands, they harvest forest trees, they perform hazard tree operations. So I don't know if you're familiar with a hazard tree, but that is a tree that threatens vehicles on nearby roads. It threatens hikers on paths. These are trees that are at risk of coming down or that have come down on forest lands that you can't just drive your F-250 up to. Or certainly not an F-150. This requires specialized knowledge, specialized equipment. The applicant also provides emergency services to Clackamas County and the state of Oregon, ODOT, when there's an ice storm that brings trees down onto roadways or onto people's homes or out in the forest. Applicant is who you call. They have contract services and they can get there. In the HCA, as identified, because of the limitations of satellite aerial photography, at the time that the site plan was prepared, the most recent aerial imaging was not in fact reflective of the property, and we did not recognize that there was an information disconnect as to what was actually happening on the ground. The aerial photography seemed to show equipment then present in the HCA, but at the time that this was submitted, there was no equipment present in the HCA. And in fact, applicant has installed a fence, and we'll be talking about that to ensure that there is no inadvertent or intentional parking, storing, using of the HCA area in any way for this.
I'm familiar with those aerial photographs.
So one thing I do
They're
want to mention
always
is
at
this
an
applicant.
angle and don't always match up with what is actually
I'm
on.
sorry, Mr. Cox, it appears you're talking, but I cannot hear you.
Oh.
Oh,
Your volume up there.
no.
Well, while Kelly's working on that, before she leaves that first screen, I just want to underscore one of the issues that that was on that screen, and that is that one of the important things, why is my video not working? Anyway, one of the important things to come out of this proceeding is a county signed land use compatibility statement issued to the DEQ, so they will issue the 1200Z permit. the applicant has been operating under a stormwater management plan that was submitted to DEQ, but that DEQ can't bless and issue until the county issues a LOX for the use. And so part of what we're hoping to come out of this proceeding is the county being comfortable to sign a land use compatibility statement so that we can resolve this 1200Z issue, get that 1200Z permit and move on. Thank you.
Ms. Kellington, can I ask a question about that? Does that land use compatibility statement, is that also include a statement that the applicant agrees that that the surrounding properties can also be developed for forestry uses? Is that what you're talking about?
No, it's different. I think what you're thinking about is a covenant not to gripe. I can't remember what they call those
Yeah,
things. No,
covenant not to complain. Yeah.
yeah, something like that, which we'd be happy to sign if that were a condition too. But no, this is something, as you know, anytime a state agency is going to issue some sort of a permit here, a 1200Z permit, they have to first get from the local government a statement that the land use for which the state agency permit would be issued is allowed as a matter of land use. And there's a bunch of boxes you can check. And one of the boxes that we're hoping will come out of this that the county will check is that the use has been approved, but it's subject to conditions of approval that have yet to be fulfilled, something like that. And then the county ships it off to DEQ. Then the DEQ finishes up on the 1200Z permit, issues it, and we're done with that chapter.
I have seen copies of that form before. You
Yeah.
exactly described it, the little checkbox. Okay.
Yep.
Thank you.
You bet.
Ms. Hudopol, thank you for your patience.
Thank you.
Can you hear me now?
Yes, my apologies. We've got two devices and the
Technology is how it
technology
is.
got away from me there for a moment. One thing that we do want to highlight is that this application we consider it precautionary. As I mentioned, this yard serves as the staging base for an in-forest, on-forest land operation. And that is an outright allowed use in the zone that does not require a conditional use permit. Forest practices include operations conducting on or pertaining to forest land, road construction and maintenance, harvesting of forest tree species, application of chemicals, disposal of slash, and removal of woody biomass. That is what the applicant does as a business. This is not a commercial storage property. It's not someone else's equipment that is being hosted here for pay. The commercial revenue that is generated is revenue as generated as a forest operation. We do have some lube appeals pending with respect to that, but I think it is important to note that under state law ORS 527-722, no unit of local government shall adopt any rules, regulations, or ordinances or take any other actions that prohibit, limit, regulate, subject to approval, or in any other way affect forest practices. And there can be no question that this proceeding is affecting forest practices. Applicant has had to stop bringing logs onto this property as part of the agreement in connection with the violation notice that the county offered. The applicant has had to stop processing some of those logs into firewood when that is when that is the ultimate destination for those logs, and that is a forest practice that is regulated on forests by the state. It could be done on the forest. It is less disruptive if it is done on this property, and so I do just want to make that note.
And you don't,
So-
Mr. Cox, you don't have to resolve this issue. If the conditional use permit is issued, we'll just agree to disagree on that issue and move along and comply with the conditions of approval. We're just protecting that argument if we need it. I don't think we're gonna, but if we did.
I do think it's an open question, and I think your direction there that we don't really need to resolve this because you've actually applied for a conditional use permit under under these regulations makes sense. If I don't have to answer it, I'm not going to answer it. Okay, Ms. Hudipole.
Thank you. So I do, staff did get this right. The application does meet all of the CUP approval criteria. As Ms. Fields mentioned, we are requesting some modifications to the proposed conditions of uses. But as far as the approval criteria themselves go, the use as staff describes it, is listed as a conditional use in the zoning district, which is commercial and processing activities in conjunction with forest uses. The forest practices uses themselves are outright allowed. The characteristics of the subject property are suitable for the use. There's no dispute about that. The proposed use complies with subsection 1007.07, which is transportation safety. This property has two permitted accesses directly onto Highway 212. ODOT has confirmed that. They've confirmed no further review on their end is required. It's right off of Highway 26 as well. It's about 600 yards east of that. So the transportation is in fact one of the appealing features of this for things like logging equipment and logging trucks. The proposed use will not alter the character of the surrounding area in a manner that substantially limits, impairs, or precludes the use of surrounding properties for the primary uses allowed in those zones. The property is surrounded by RRFF 5 lands and EFU lands. The property to the west, which has raised some concerns in this proceeding, is an RRFF 5 zoned property. Staff agrees that this condition is met. Opponent potentially disagrees. It's unclear. Opponent does acknowledge that the uses of this particular area, the surrounding area, are largely industrial and commercial in nature. The proposed use is consistent with the goals and policies of the comprehensive plan. There's no dispute about that. And the use complies with the applicable requirements of the zoning district. And this says there are no overlays. To the extent that overlays relating to HCA or water quality apply, they are met, particularly with the limited conditions. And we'll discuss that a little bit farther relating to those areas. But there is no disagreement that a condition that any use of the HCA would require an HCA permit, and none is sought here because no use of the HCA is proposed as part of this application. So I'd like to introduce you to the O'Malley brothers. They're a forestry operation. That is what they do. They go up into the forest. They also do some road work and maintenance relating to forest lands. But they do commercial logging and forest lands. They provide emergency services related to forestry practices. That's what their equipment is for. That's what the vehicles are used for, is to transport crew and equipment up into the forest. That's what everything on this site is in service of. So they specialize in timber harvest and logistics, hazard tree removal, wildfire fuel reduction, and then they do projects for both private and public landowners. They have emergency response capabilities. They do field logistics with their staging yard in order to make sure that the impacts directly on forest lands are minimized. Anything that is stored on this site instead of being stored in the forest itself is better for the forest lands. So having a staging yard so that only the equipment that is necessary for that one project during the time at issue is on the forest lands and everything else can be off is critical. It also is important to note that having these regional or distributed sites is very important for forest safety and emergency response. You can't confine operations like this to a single zone, which is, I think, why the state law allows forest practices in rural areas. And the reason for that is if you've got a wildfire that's cutting a highway off down the middle, you really do want to have equipment ready on both sides of that fire. If an ice storm brings down some serious poles, trees onto a highway, you need equipment that can get to it. And if a wildfire directly threatens a staging yard, you sure hope there are some other staging yards nearby that are out of the path and can mobilize. So the subject property is as described, just east of the Highway 212-26 interchange. Uh, and this is just an zoomed out view a little bit to show it in context. It's clear from this image the extent to which other nearby properties are industrialized and used for commercial purposes. This is not a logging operation in the middle of a residential zone. This is the logging yard that is surrounded by other industrial and commercial uses.
Your slide, you meant Highway 212, correct?
Yes.
Yeah. Okay.
Oh, yes. I apologize for that typo.
No,
It's
I
correct in the
take
second
typos
bullet
too.
point.
It's hard to see them after a while, especially in captions. I don't know why.
Yes. So in addition to the light industrial and commercial, there's horse uses, equestrian uses that we believe occur or understand occur on the farm to the west, and on the east there's a pig farm. ZDO 12 under ZDO 120303, the first approval criteria is that um, the use be allowed in the zoning district as a conditional use, and this is a screenshot from ZDO table 316-1. There's no dispute about that. We've also got the outright allowed uses, forest practices, and conservation areas or structures for the conservation of water, soil, forest, or wildlife habitat resources. O'Malley Brothers does do uh, conservation work. They restore stream habitats, and some of the logs that they bring onto the property are dimensioned and used for those purposes. As you heard, there's no dispute that the characteristics of the property relating to size, shape, location, topography, existence of improvements, and natural features are all appropriate to the use that's being made. You can see in this image, it's facing the east, and so the southern area with the protected water resource and the habitat conservation area are on the right-hand side. You can see it's a sizable chunk. You can also see, and we'll get some close-ups of this a little bit later on, but there's a sort of a light brown area separated from the actual operation that has a pretty stark line. That line is a bright orange fence that was installed using GPS coordinates to demarcate and separate the HCA from the operations. That fence is still in place, and there are no equipment or materials on the south side of that fence.
Right. And I saw that the county had a recommended condition of approval requiring a survey for all of this. Is that
Our understanding is that there was a condition of approval requiring a site survey to ensure that setbacks are met. We have provided a declaration from a geologist as to how the fence line was constructed. That was one of the exhibits, and I do want to ensure that my understanding, I think I've heard everyone refer to them, but I should say on the record that we submitted a bench brief with 6 exhibits yesterday. We also submitted a letter discussing drainage submitted by Wendy Kellington. And we'd like to make sure all of those are in the record along with the PDF of this presentation that we submitted.
perfect? And I did receive those, but as I explained, I had not refreshed my browser or whatever the mystery of it is. And I
Yes.
looked at it for it last night and didn't see any new material, so I didn't see it until shortly before this hearing. I want to talk. I interrupted you briefly, and thanks for your patience here because I saw that this is a good shot of the property, and I saw it in some of the exhibits. So the setbacks for the front on this are 30 feet, and I see what appears to be a Connex container between the fence and the road out in the front, and maybe that's been moved, but. I see that, and I think the setbacks to the side, it looks like they can be met as well, but it appears you still have some storage building or container out in the setback area in the front. Is that going to be moved, or what's the plan here?
Yes. This is an important distinction, and we'll talk a little bit more about it later, but I'm glad to have this brought up early so that we can clarify. There are only 3 Conex containers on this property that stay there, that are actually used for the storage and equipment that stay on the property.
Okay.
All of the other Conex containers are taken into the forest. And so these Conex containers that you see, sometimes they are temporarily left there if they're brought from one job and taken off. We understand as a condition of approval that the county would require that that not happen in front of the fence line anymore, and that's agreeable.
But that it's important to understand that the conics that you're looking at, Mr. Cox, that's in the front by the highway, is on the back of a trailer. It's not even on the ground. It's mobile. It will, its life will be spent on a forest site when the jobs start again, when the weather gets terrible, or when we get a fire, whatever it is. And it'll sit there with the chainsaws and expensive equipment that can't otherwise just be left in the forest and that you can't schlep back and forth as a practical matter.
Okay, and I think we're on the same page about this. Either way, if it's a Connex container, it's a building and it needs to be within the setbacks. And if it's equipment, mobile, something that's used in conjunction with these commercial activities, it needs to be stored in the appropriate storage area. Right?
So
And-
we
and
don't
we're going-
we don't mind moving it from its location where it is to somewhere else on the property. That's not a problem. But as Kelly will get into a little bit, we are pushing back on the idea that a Connex is a building. We view it more as a piece of equipment, at least the way that they are customarily used in forestry operations. And she'll talk a little bit about that. I think when they are used as extensions of, grocery stores in urban growth boundaries, that's one thing. But when they are, really the equipment, part of a forest operation, that they really cannot be and are not buildings. They don't fit. They're not made to sit on the ground. They're made to sit on a barge or the back of a truck, or they can be on the ground too, but they're not built to be affixed to the ground. They're built to just be really used as equipment. But she'll talk about that.
I agree, and it's unreasonably complicated. I mean, there's all that discussion about is it pertinent to the ground, or is it? I think it's both. It can be either a building or a piece of equipment, or a commercial, like it's just a trailer, right? So please proceed, Ms. Hudable.
Thank you. So as I mentioned, we did submit, you'll see in the materials that were submitted yesterday, a few exhibits. One is a sworn declaration from a principal field geologist about the methods used to create, to identify that fence line, and that it extends all the way from the eastern boundary of the property as far west as it could get before it ran into vegetation that was so dense as to preclude the fence from being extended any farther. So that is fenced, and it was the declaration does say that the boundary was determined using best industry practices.
Thank you.
And one other, there is also a declaration from Mr. O'Malley, which explains that he retained the geologist's company to perform that work, and also that the purpose of the fence is to ensure that no use occurs on the southern side of it. Mr. O'Malley also provides some details about how Conex containers are used in his forest operation.
Thank you.
I think we've covered all of this pretty well. So the next subsection or condition of approval is that transportation facilities, we've already discussed those. ODOT has approved permitted both the accesses and requires no further approval. And this is on Highway 212. And so the access is excellent. We do have exhibits from traffic engineer Mike Ard confirming that, in fact, applicants' use of the highway facility is fairly minimal, and by and large occurs outside of peak commuting hours. So applicants' peak hours are not the same as commuting hours. We also have a traffic analysis conclusion that there is no transportation related mitigations necessary. And there's no change of use for purposes of ODOT's regulations. And this is just an image that shows that we've got the two accesses and that ODOT has confirmed them. Those are in applicant's Exhibit H. The fourth criteria of approval is that the proposed use will not alter the character of the surrounding area in a manner that substantially limits, impairs, or precludes the use of the surrounding properties for the primary purposes allowed in the zone. You can see here on this map some of the other businesses that are nearby. There's an auto wrecking yard. There's Boring Bark, which is landscape supply. A little bit to the west, we've got a striping and painting business, a paving business, a well drilling business. This is the direct area we're talking about. The O'Malley Brothers property is marked with a yellow pin to the left of Highway 212 in this particular image. You can see there's a considerable amount of industrial use nearby. These are images of the Boring Bark site from the street and as an aerial view. There's also Western Bus Sales, which has a large facility across the street from the subject property, as does BNR Auto Wrecking. And other industrial uses include an RV sales and storage. There are shed sales and some of the other businesses that I mentioned. There's an auto mechanic. There's heavy equipment sales nearby. And these are just some images of what Highway 212 looks like right in this area here, showing that it's generally commercial in nature. This is the property next door to the subject property on the eastern side, just to give you an idea of what the pig farm looks like from the street. This property is quite well buffered from the other uses. There's 200 plus feet of mature vegetation on the southern side of the property that is buffering it from the use on the south. It's got 2 rows of evergreen trees on the front of the property that buffer it from Highway 212, one that's right next to the right-of-way, and one that is behind the 6-foot tall privacy fence. There are some newly planted evergreen trees on the eastern border. We understand that the county would like a condition of use that if any of those trees die or become diseased, they'll be replaced. There's no objection to that condition. There's an existing berm on that side of the property. The western side of the property has continuous mature tree lines. So here's a view from the north showing that Highway 212 frontage and the 2 rows of evergreen plantings and the privacy fence. On the south side, that yellow line is about 250 feet, just to give you an idea of the depth of those trees. You can see there's a tiny little yellow line on this image of the west side. That little yellow line is 26 feet. So that gives you some context for how much vegetation is running along the west side between it and the neighboring property. That property on the west are the opponents who submitted materials for the first time yesterday concerning drainage and zoning. I'd like to state that although this is not a zoning application, the zoning of the land is not something within applicant's control. If either opponents or the county were to propose a zoning change for this area or for the property on the west to rural commercial or rural industrial, applicant would not oppose that application. And on the east side, this is just some close-up images because those are less visible from the aerial, exactly how everything is laid out. So there's an image showing the berm on the east side and the newly planted evergreen trees.
Thank you.
You're welcome. There's the east side, and then opponents acknowledge that for purposes of the character of this area, which is what condition 4 is concerning, applicant's use is in harmony with the surrounding. They're requesting a zone change to commercial industrial for the specific reason that that is what this area is used for by property owners. So it does not sound like that there is any dispute that applicant's business is in the same, it is the same character as the surrounding uses. And that's, largely due to the fact that there are 2 state highways nearby. There are intensive industrial and commercial uses. Though the evidence is that the primary uses that are allowed in this zone in the nearby zoning districts are going to be unaffected by this use. Opponent did raise the idea of sort of the aesthetics of the business, but that this business's aesthetics are not out of character with the surrounding areas. We are not talking about a suburban residential development or a regional town center. This is rural, and that's what the properties nearby are used for. Opponents also do raise the drainage going from east to west, as mentioned. That's governed by state law. State law sets the rules for which properties can drain where. Historic drainage rights not only can be maintained, but in most or many circumstances must by state law be maintained to a certain extent. That's the case here. DEQ is setting the standards for precisely how the drainage on this property needs to work in order to comply with state law. And those laws they're well settled. The fact that the property drains from east to west is not a basis for denying the conditional use permit, and there's no evidence that the applicant has done anything to increase the flow onto the western property. To the contrary, they've taken actions that would reduce drainage. For example, by cleaning out a specific ditch and diverting some more water that comes to it from the east boundary to an ODOT ditch on the north property. And that is water that otherwise would have gone to the western neighbor.
So let me clarify that there's been no diverting here, but there is an existing ditch on the east side that I believe is on the kind of on the property line between the subject property and the pig farm. And O'Malley simply cleaned it out so that there's an impoundment, a water impoundment on the pig farm so that water would drain better through that ditch. But O'Malley hasn't diverted any water anywhere.
Where does the existing ditch terminate?
So that ditch that used to be in the middle of the property isn't there anymore. O'Malley says, he's not the one that changed it and made it go away. DEQ says, you are. And again, the two of them are just sort of agreeing to disagree. And O'Malley is going to restore that historic ditch that will then convey water from the impoundment to the east across the O'Malley property to the property to the west, because that's the historic drainage. And as Ms. Hudipol mentioned, the Oregon state law requires property owners downgrading to accept a natural drainage that comes from upstream. No property owner is allowed to divert water to increase the flow of water on another property, but that's not what's going on here. I think probably what DEQ is going to require is that historic flow, that instead of now it goes from that ditch on the east of the subject property to the ODOT ditch, instead of going there, that it conveys through the center of this property the way, sort of God intended it to, the natural way, which will end up on the west side of the property. And the opponent doesn't like the fact that they're down gradient and that water drains to their property. But not only is the applicant here not in a position to do anything about it, but DEQ is very much in charge of that issue, and they are going to make sure that the natural drainage is what's happening.
I read the DEQ letter on that, the initial one anyway. If there's a subsequent one that you're citing in the materials you submitted last night, then I skimmed it as well as I could, but I moved pretty quick. That requirement then is based on DEQ findings, and regardless of whether your client here agrees with all of those findings, what I hear you saying is that your client is reaching an agreement to restore it the way DEQ says it was, correct? It's a DEQ requirement.
It's a DEQ requirement.
Put back together or
Yes.
excavated and put back the way DEQ says it was before it was disturbed.
That's right. And we won't be, we'll be agreeing to disagree about who done it. This property has been used by a variety of masters over time. And the important thing, though, is that DEQ is not claiming that that old ditch is a wetland, probably because it's just the area is just also disturbed and has been for a long time. But going back to where we started, the potential wetland on the property is in the back, where the only wetland that shows up on the state wetland inventory is. We've talked about that. Don't need to beat that horse. This ditch is something different. It's something that DEQ would like to have resolved to convey the historic drainage from east to west. So,
And
yeah.
and it's not then the emergent stream that they discussed.
No,
That's
that is
something
not,
else
that's
too.
not where, that's not where this is going to come out.
Okay,
No.
just making sure I understood. Thank you.
Yeah,
for
there's a
clarifying.
letter in the record from the certified smart guy who's been dealing with DEQ, Bo Ellis. He's a lawyer, does environmental work. I don't. And he wrote a letter for the record that just kind of explains how all that's going forward. But I think respectfully, our thought would be in this land use process that it would be enough to require that the applicant comply with whatever it is that, DEQ wants them to do, if they, the 1200Z permit conditions and those sorts of things, and then let DEQ, do what it does.
Thank you. Ms. Hudipole, thank you for your patience.
Thank you very much. And I've put up on the screen, what's being shared right now is an image that is in the letter Ms. Kellington just referenced from Bo Ellis. This is applicant's exhibit S. And this I just pulled up the image showing the blue area is the HCA conservation area that we are talking about when it comes to the water quality resource in the HCA. The green area is where there was decades ago a historic drainage ditch that conveyed water from east to west, and that DEQ, and it's that specific area or that original water that DEQ's process is concerned with. And so this just shows the two different areas of the property at issue.
Okay, thank you for that. I think that's very clear. Thank you.
You're welcome. And this is just another excerpt from the opponent testimony discussing the drainage and the zone change they request. Again, that's not opposed, and applicant is working with DEQ to do what DEQ requires. And so nothing about opponent's letter affects how this standard applies to the property. There's nothing about this use or the proposed use that is interfering with the uses allowed in the primary uses allowed in the zone on the property. It's not a use that generates substantial amounts of noise. It's not running heavy equipment, 8 or 10 or 12 hours a day. There are trucks that go in and out of the property, and there is unloading of logs. But the logs aren't processed. They don't run a mill on this site. There's nothing along those lines. So the weight of the evidence in the record is that the fourth criteria is met. The fifth criteria of approval is that the proposed use is consistent with the applicable goals and policies of the comprehensive plan. There's no dispute from the county that those are met. This operation does conserve and protect forest lands. It provides employment in the forest products industry. It protects and maintains environmentally sensitive areas, wildlife habitat, scenic corridors, and in particular, as mentioned before, by allowing equipment to be stored out of the forest, the staging yard itself is protecting the forest. It goes beyond just the in-forest activities. It is the off-forest storage that also helps to protect the state's lands and to help maintain water and land resources in forest areas. And also it creates, it's consistent with maintaining the growth of the wood products industry by harvesting trees. And and it supports the principles and implementation of the Forest Practices Act. And this is a very, very similar list from the comprehensive plan. And I put a mark on it to note that it's not a duplicate. This is actually a different section in a different chapter of the comprehensive plan that restates the same essential goals. That's how important this is. And for the reasons that we've already discussed, this operation complies with that. I'd also note that the Oregon Forest Industries Council has recognized that forest operators like the O'Malley brothers are critical resources in firefighting, not because they are direct firefighters, but because they know how to get equipment into the woods. They know how to get it there quickly. They know how to clear fire breaks and do some of the work that has to be done in order to protect communities. At the end of the day, the comprehensive plan wants to encourage forest-related industries, and that's precisely what applicant does with this property. It does comply with the applicable requirements of the zone. You can see the minimum lot size and setbacks. All of those can be met. We've got the outright allowed uses and the commercial or processing activities that are conditional uses. So the site location, this is zoomed out a little bit. You can see the yellow pin sort of toward the bottom right of this image shows where it is relative to Gresham, Kelly Creek, Powell Valley, Pleasant Home. And this is another image showing what the site looks like in the context of some of its more immediate surrounding neighbors. It is appropriate for the site. It's not a public business. The public is not invited on site. It doesn't even have an office for employees. Employees do not work on site beyond the work of loading and unloading equipment and logs. They drive to the site and they drive away with whatever equipment. This is not a site where there are architectural considerations because there are people on site all day, every day. That simply isn't what this site is for. The county went over the basic site plan showing where employee parking is proposed to be located. There will be fewer than 15 parking spaces. Discussions with the county suggest that the county proposes not more than 6 parking spaces, or that 6 be provided. We think that is the correct amount. There's no dispute about that. Applicant is happy to submit a plan that shows in more detail exactly where those will be located, what the size of them will be, and that they meet the standard requirement, or that they meet the standards in the county's code. We've got log storage shown down. So there's the purple HCA line that is shown on this image, and just above it on the east side of the property, there's the logging, storage, traffic control devices, and shop supplies that are marked there. Those are the only 3 Conex containers that are not relocated into the forest. Instead, those are where forestry equipment are stored. They are in direct support. That's equipment and tools that are in direct support of the forestry practices that occur on forest lands, but those 3 Conex containers remain on site so that some equipment is just available to be loaded out for each individual job.
Kelly, can I make a note real quick
Yes.
that you discussed county's position about 6 parking spaces? That is from the conversation we had yesterday about, or earlier this week, about the conditions of approval. And so the hearings officer may find that that may not be worded as such in the staff report. But because the applicant identifies that there are up to 6 employees coming to the site on a potentially daily basis in their private vehicles, that it seems necessary to have 6 parking spaces to serve those employees. You will not find that in the discussion for 1015, because 1015 talks about the parking requirements based on floor area. And so I just wanted to make that clarification.
Okay. 6. Are you settled on 6, Ms. Hudipole? It's 6 parking spaces. I don't want to put anything in here that just limits you, but what I'm considering here is that modifying or putting in or proposing anyway for discussion here. How's that? A condition of approval that if that prior to increasing the number of parking spaces to 15 or more, you'll go through the process of design review and meet the landscaping requirements of the 1000 series, just so you don't have to revisit this, hopefully ever. So,
I was going to propose just that very thing, and so I
okay.
think that's an excellent way to resolve that, as applicant will agree to a condition of approval that it will seek the appropriate permits or provide the information if it will have 15 or more spaces, and that this would only authorize 14 or fewer spaces.
Joy, thanks for raising that. Appreciate it. Appreciate you
Yes,
very
thanks.
much.
Okay, I'll work something out. Okay.
Make sure I'm in the. So we've discussed this.
Yeah, I don't think we need to do this anymore, this part of
Yeah,
it. I think we're
we've
good.
discussed this. I did want to call out, we do have an excerpt here from Evan Brugman's, the principal field biologist declaration, where this expert just sort of shows what it is that was done in order to create that fence line and shows where it is. Just a couple different aerial views of the same fence. I'll note that in this particular one, the image on the left came directly from the staff report at page 17. And so that image showing the fencing and the fact that it has been there for some time is in the record in the staff report, as well as the materials we submitted yesterday. We also had a professional wetland consultant who submitted correspondence explaining that he has visited this property and expects that any wetlands on the property would be confined within the existing HCA. One of the modifications that we're requesting is that the biologist prepare a formal statement of whether or not there are indicators of wetlands outside the HCA, or that wetlands from that south protected water resource that go outside the HCA. And if there are, applicant would agree to a delineation of those wetlands. But if the biologist goes out and opines that any wetlands associated with that protected water resource are inside the HCA, there's no indication they go outside of it, and that area is not going to be disturbed, we would propose that the delineation not be required, because there would be no indication that it's called for, that there will be any disturbance that would affect wetlands. So that is one of the modifications that we are requesting for the condition of approval, is that the delineation only be required if the southern resource has wetlands outside the HCA.
Thank you.
This is what I referenced earlier, the declaration from Mr. O'Malley, just explaining why Everin Northwest was brought out, and that the demarcation fence is there for the specific purpose of keeping operations out of the HCA, and that in fact, since it has been built, there's been nothing occurring on the south side of it. There are not expected to be any impacts on wetlands as a result of the proposed use. Let's make sure I've.
Not showing up very well.
No, it's thinking, I think.
So I think we've done wetlands. I don't think we need to do that anymore.
Yes. So we are requesting a limited design review that really does just focus on the stormwater, any grading that is required, and the waste receptacle that Ms. Fields identified. We're asking that the subsection Z03, which applies to building design review, not be applied. That is not a section that typically applies in this zone. It would not normally apply. The only reason the county has explained it is requesting site review at all is just for this grading work and to verify that we're not affecting the southern water resource. And none of that would be affected in any way if site design for buildings was in some way required. Now, with that said, the Connex containers here are not buildings. They're not buildings under the county's definition, and I'll explain that in just a moment. The prior decision by Hearings Officer Turner did not consider or purport to consider the entirety of the definition in the structure, and I'll show that in just a moment. But starting with the mobile units, those mobile units are not designed to remain on the ground. They're on trailers. They go out into the forest. They come back. They are equipment. They are a piece of equipment. They are necessary to forest operations. The thing about Connex containers is they are a standardized mobile unit. They are specifically designed so that they are easy to put on a rail car, a ship, a barge, a truck, a pallet. They are meant to be mobile. They are meant to be easy to work with. They are specifically built. They're transported on huge container ships, not undercover, and they are meant to withstand harsh weather conditions. They are not fireproof in the sense that you can get them hot enough that you can cause internal combustion, but they are highly fire resistant, meaning that they will protect their interior from exterior flame or sparks jumping in. They also have a very high melting point. And so they are fantastic for use out in the forest. You would never want a wood-built structure, something made with wood or flammable material to do the job that these Connex containers are doing. And nothing can do that job like these can. Because they are standardized, no matter where you are, if you need to find a truck to move it and move it quickly, it's going to be easy to do. The same can't be said for anything that provides a similar degree of storage and protection out in the elements. These are the one and only. And they're used by by forestry operations, commonly including this one. They are also agricultural buildings by definition because they are being used to store forestry equipment. That is a defined use of an agricultural.
Let me stop you there. They're really not buildings, but if they were buildings,
If they
they
were,
would be
yes.
considered agricultural buildings. They're really not. They really are equipment. And as soon as you apply, the building code or facade standards, I mean, the wheels come off. They're no longer suitable for their intended function.
That
Sorry,
was
go
funny.
on.
The wheels come off in this conversation about the Connex. I
Yeah, right.
understand.
Yeah.
Yeah. I'm going to look at this and really puzzle over it a bit because I've typically required if the wheels are off, literally, and they're on the ground, I've viewed them as buildings that require either a building permit or an ag exempt application as an alternative. And so, but I'll puzzle over this, and I'm going to reread what you wrote about this, and I will do that.
Yeah, one of the things that I thought about is sort of a syllogism. All fish can swim, Wendy can swim, but Wendy's not a fish. And I think there's sort of a similar sort of symmetry here that, Conex containers can sit on the ground, but
Right.
that's not what they're meant to do. They're really meant to serve as equipment as Kelly said. And, if you do call them buildings, here they're clearly ag buildings. As you know, the statutory definition of ag buildings includes buildings used in forest uses. And there's also a statute that says in 215-760 that in zones that allow, mixed farm and forest uses, which the RFF5 zone would be, that you have to allow buildings that serve forest uses. So, I mean, there's a lot of different ways to get to it, but from Kelly's and my point of view, it just makes more sense to kind of call them what they are and pieces of equipment.
I'll puzzle over it a bit, for sure. Go ahead, Ms. Hudipole. Or is that?
So one thing I do want to point out is staff did reference a hearings officer decision in a different case that found that Conex containers are structures. And there are some important things to understand about that decision. First of all, this was a Conex container that was proposed to be attached to a permanent grocery store building in the RCC zone. The retail commercial center was across the street from Clackamas Town Center. And so we're talking about a highly dense urban use affixed to a permanent building. And in that opinion, the full definition of structure was neither in the HO opinion or in the staff decision. Neither one actually set out the entire definition of structure. And I have a screenshot from the staff decisions of the one and only reference to ZDO-202 in that opinion, and we've offered both as exhibits with our submittal yesterday, which defines structure as anything constructed or erected. And that's not the definition. It's anything constructed or erected which requires location on the ground or attached to something having a location on the ground.
Okay. I
And
see your point. It's certainly not that because it doesn't require us like a foundation.
Right.
yes, and I included some materials in our submittal showing just that the number one use of Conex containers is for shipping, international shipping around the world. And so this is the same definition. This one, the little excerpt here for the finding, that's directly from the HO's opinion. And this just shows where from the staff report, where the property was located and the manner in which the Conex container was proposed to be used, which is at the bottom of that site plan, the hashed area. It's on a loading dock. It was proposed to replace one. And under ORS 527-522, regulating regardless of whether they are on wheels or not on wheels, regulating these Conex containers that are used to host forestry equipment for staging to be used in the forest would affect forest practices on forest lands. And we'd refer you to ORS 527-522, which, like the other statutes cited just a few screens back, really indicates these buildings are not meant to go through any sort of a design review process.
Building these connexes. That's what you
Yes,
meant. I know
Conex
you.
containers.
Okay.
And so we do have an overview of just the conditions and clarifications. We agree to accept without any sort of revision most of what has been proposed. We're proposing revisions to conditions number 4, 7, 9, 10, 14, and 15, primarily to request clarity, either in what the condition itself is requiring, or to the extent there are a few specifically relating to the water quality resource in the HCA that we are requesting sort of a replacement condition. With the HCA, it would be that if any use is proposed to be conducted in the HCA, or if any disturbance is expected in the HCA, we would get the appropriate permit, and then a delineation not be required unless the wetland from that southern protected resource is expected to exceed the HCA's boundary.
Makes sense. It should only be required if it's relevant.
Yes. Yes.
We would like clarifying language added to condition number 4. It's a pretty straightforward issue. That condition is written requires coordinated installation of necessary water, septic, and surface water management facilities. We are proposing a surface water management facility, but no water or sewage or septic, excuse me. And so we would just like a note added to that condition that the condition is not intended to require installation of any facilities that applicant has not proposed, but that if such facility, but only to clarify or to condition that if such facilities are proposed or added, the appropriate coordination would occur. The language that we have proposed would be the condition does not independently require installation of water, septic, or surface water facilities. Rather, if any such facilities are installed or modified in connection with the approved use, such work shall comply with the regulations of the applicable management authority.
Okay. And you submitted that language with your submittal. Okay.
We do have a summary of that language in the table.
Perfect.
And now that it is on the record orally, if there should be a transcript that could be made to provide the language that has just been entered into the record via the recording as well.
Will you submit it with your exhibit by 4 p.m. on the day the record closes? Either way. Thank you.
We will make that happen, yes. The proposed let's see, number 7, what we have requested is that it's what we've already discussed, limited to the code compliant design of on-site walkways, driveway circulation, parking spaces not to exceed 14, and any on-site lighting fixtures. We will provide verification to the county that those are in compliance with its standards
And also the trash receptacles.
and the trash receptacles, yes, and I will get that added.
Okay. Same thing, I'll look for your proposed language by 4 p.m. on the day the record closes, if not sooner. I would think you could do it by 4 p.m. today pretty easily.
Absolutely.
Yes, no question.
We propose replacing condition number 9 for the reasons that we've already discussed, which is just that no storage, staging, or development is authorized within the HCA by the permit, and no such activity shall occur within the HCA. If applicant or any future owner proposes development or use within the HCA, that activity will comply with then applicable HCA, HCAD requirements, including required permits.
Okay, thank you. And you said 14 and 15.
We've already discussed number 10, that's the wetland delineation. I'm just checking to see if there's anything else that I want to raise in case the county has a specific response. Condition number 14, we would just like it clarified to communicate clearly that it is not purporting to regulate the subject property's access onto Highway 212. It's not imposing any new requirement or condition over and above what ODOT already requires for access onto Highway 212.
Those accesses are entirely within the jurisdiction of ODOT, so I don't see there's an issue there.
Okay. And we would like to just clarify the language of condition 15 as well. As it is written, it might appear to require additional documentation of ODOT's of applicants' ability to use its ODOT accesses, but we've already provided that documentation in Exhibit H, and so just want to clarify nothing further is being required unless ODOT requires something.
Okay, I see that. And again, it's all ODOT's purview, so, okay.
I don't think we need to cover the reasons why. So we'd like to thank everyone again for their time and invite any questions. If you have any, Mr. Cox, Hearings Officer Cox, that have not been asked, we'd be happy to answer those.
As you saw, I really do prefer to ask the questions as things are in front of me, because I just think it's appropriate to do it at that time instead of trying to say to someone, can you pull up the screen on such and such a exhibit, and it just takes forever. So thank you for your patience with my questions and for thoroughly answering them. Did the county have any additional comment here?
I have 2 clarifying items.
Okay.
The applicant throughout the presentation mentioned that there's 3 Connex storage containers that live on site for storage and are not taken off site. The aerial image from 2015 that's included in the staff report shows 4 of those in the covered wood storage area. There appears to be 4 Connex storage containers situated on the ground there. That's one piece. And then the fence that the applicant talks about separating the proposed use from the habitat conservation area. Based on the aerial images, it looks like it might just be a temporary construction fence, like a used in construction for keeping equipment out of areas. I wanted to clarify whether that was going to be built as a permanent fence, whether the orange construction fence was going to be replaced with a permanent fence to ensure that no activity occurred in the HCA, or whether the fence you were referring to was only that temporary construction fence.
So I'll answer the last one first, and that is that our hope was that we could just maintain the orange fencing. It's inexpensive, it's very bright, it's very clear where you're supposed to stay out of. And if it's all the same, we'd like to just maintain that. It's where it's supposed to be. It keeps people and activity out of the place it's supposed to be. So it kind of does what it's paid to do, but doesn't cost a lot. So that would be our preference if possible. And I think on the Connex thing, I'm looking at the same image you are. I'm wondering if we just misspoke. It sure looks like there's four to me. Kelly, are there three or four? Connex
There
is
are four. That was somehow an error that was populated. So my apologies for that. It is four. We have verified that.
cool. Thank you. Joy, thanks for catching that, because sure as anything, assuming this thing gets approved, we'd have gotten a condition about three, and then we had four, and we'd be right back begging. So thank you for catching that.
And that is all I had to clarify.
All right. At this time, I'd like to provide time for members of the public who want to participate and make a comment for consideration in this application.
I have Scott Teeny,
Scott, how do you spell the last name?
Teeny.
N-Y. Okay, thank you. Mr. Teeny, would you please state your name and address for the record?
Yes, my name is Scott Teeny. My address is 564 Teeny Drive in Metolius, Oregon, 97741.
Thank you. Please provide your public input, and I appreciate your time to engage in this process.
Yeah, my pleasure. The first thing is I'll give you my background real quick. I promise I won't bore you. I have been a developer and a builder. My siblings, myself, and my father and mother purchased the property immediately to the west back in the 1970s, and it is residential property to my understanding. And now we inherited, my father bought us all out years ago, and now we inherited the property back, us kids. And so that's why myself, my sister Suzette Penniman, and my sister Andrea Lorenz, or some of you may be dealing with or have. So that's enough background. So what I'd like to ask, is our property that's immediately to the west RR5 or is it RRFF5? Can anybody clarify that?
I believe.
I'm sorry.
RRFF5.
Okay, thank you. So here's my couple of concerns. One is that the traffic impact study said that the traffic comes at 4:30 in the morning to 5:30 in the morning. So the employees arrive. I'm actually an excavator and a contractor, so I totally understand what's going on here. And so they arrive 4:30 or so, they fire up their diesel engine, logging trucks, whatever equipment they're going to take, semi trucks, etc., and then they leave. Is there a time frame? Because we are immediately adjacent the next four properties, and we share 1,200 lineal feet or more of contiguous property line. So I'm a little concerned about that noise level that early in the morning. And right now, our property is being used via a contract with the neighbor two doors down. Um, for equestrian use, okay? But we intend to build on this at some point. So you have to see us as having residences immediately adjacent, like we used to have, and intend to have again at some point fairly soon. We just re-inherited this property in the last 24 months, okay? And so what's the time frame for them being able to come and go and honestly make a bit of noise? I'm in construction. I know how it is. Can anybody answer that for me?
Are you asking me to make a statement about what the noise regulation is? There's a
Yes,
noise
certainly.
ordinance for Clackamas County, so you would, the noise ordinance would control this.
Okay. All right. I guess I'll do some research on that. That's a really big concern that I want added to the record because we're residential right next door. And I don't want to stop their operation. I like to see people be in business and flourish and all that, but we need some consideration there. My one other concern is, um, well, we're going to have a survey and a perimeter fence on, at least on our side of this application. Is that a condition of approval?
It is. There is a condition of approval proposed at least. Um, on the proposed condition of approval is number 8, which is one of the conditions that were we just discussed were accepted by the applicant, and it's setbacks from the eastern property line for all existing structures shall be verified by a site plan prepared and stamped by our Oregon registered professional land surveyor. So,
Okay. All right. Great. Thank you. I appreciate knowing that. Will there be any kind of a perimeter fence that delineates where that property line is?
I don't think that that was required. There, what was required were landscape type buffers, visual buffers.
Right, I heard that. Yeah.
Yeah.
So I guess I'd like to request that the staff consider adding that as a requirement that there's some kind, I don't care if it's a simple metal T-post and barbed wire fence or no barbs, just a wire fence, something, because I believe we've been encroached on in the past. Um, and so it'd just be nice to know that we're on the right side of the fence and both from both sides.
Okay. Thank you, sir. And
Uh-huh.
thank you for your participation in this land use application hearing and your citizenship.
Yeah, my pleasure.
Are there any requests to keep the record open? Let me read a statement.
Not from the applicant.
Does any party or member of the audience want an opportunity to provide additional evidence, arguments, or testimony? Does the applicant wish to waive the period for final written argument?
We will do that, but we are going to submit by 4 o'clock today the recommended conditions of approval that were discussed earlier.
By 4 p.m. today, then I'm going to state that that the record will close at 4 p.m. today. There was no request to keep the record open. And is the applicant wish to waive any additional period for final written argument? You're entitled to an additional 7 days.
No, I know I dread the 777s, and
That's what we're talking about.
yeah, I don't see any reason for it, unless somebody submits some monster report or something that is
I'll
an, oh
tell you
my
what,
God.
I think it's ridiculous to make the applicant decide before the record is closed whether they're going to waive the period for final written argument. Submit at 4 or after 4 just a written statement to Ms. Fields that you choose to waive the period for final written argument. So you have an opportunity to see what is submitted to the record before you make a decision about waiving the, yes, Ms. Fields.
I will be sure to get anything uploaded to Acela that is received before 4 p.m. By 5 p.m. today. So you will know by 5 p.m. what has been received.
So what I'm asking is anything you want submitted to the record by 4 p.m. today, your answer about the applicant's final written argument period does not have to be by 4 p.m. That's fine. Just submit something. Okay?
Yeah.
With,
I'm 99.9% sure we're gonna waive that. So just heads up, but thank you for that. That's courteous.
with that, I will close the hearing now, keeping the record open as discussed till 4 p.m. and possibly the period for the applicant's final written argument beyond that. That's to be determined. Thank you all.
Thank you.
It was my pleasure to do this.
Okay.
Take care.
Thank
Take
you
care.
very much.
Bye-bye.